About the state executive in the series of our constitution. The general structure of the state executive. As stated at the outset, our constitution provides for a federal government having separate systems of administration for the union and its units, namely the states. The constitution contains provisions for the governance of both. It lays down a uniform structure for the state government in Part 6 of the Constitution, which is applicable to all the states save and except the state of Jammu and Kashmir, which has a separate constitution for its state government, for reasons which will be explained in chapter 15. Broadly speaking, the pattern of government in the states is the same as that for the union, namely a parliamentary system. The executive head being a constitutional ruler who is to act according to the advice of ministers responsible to the state legislature or its popular house, where there are two houses, except in matters in respect of which the governor of the state is empowered by the constitution to act in his discretion. Article 163(1). The governor, at the head of the executive power of a state, is the governor, just as the president stands at the head of the executive power of the union. The executive power of the state is vested in the governor, and all executive action of the state has to be taken in the name of the governor. Normally, there shall be a governor for each state, but an amendment of 1956 makes it possible to appoint the same person as the governor for the two or more states. The governor of a state is not elected, but is appointed by the president and holds his office at the pleasure of the president. Any citizen of India who has completed 35 years of age is eligible for the office, but he must not hold any other office of profit, nor be a member of the legislature of the union or any state. Article 158. There is no bar to the selection of a governor from amongst members of a legislature, but if a member of a legislature is appointed governor, he ceases to be a member immediately upon such appointment. The normal term of a governor's office shall be 5 years, but it may be terminated earlier by dismissal by the president, at whose pleasure he holds the office. The second, resignation. Article 156(2). The grounds upon which a governor may be removed by the president are not laid down in the constitution, but it is obvious that the power will be sparingly used to meet with cases of gross delinquency, such as bribery, corruption, treason, and like a violation of the constitution. There is no bar to a person being appointed governor more than once. The original plan in the draft constitution was to have elected governors, but in the Constituent Assembly it was replaced by the method of appointment by the president upon the following arguments. It would save the country from the evil consequences of still another election run on personal issues, to sink every province into the vortex of an election with millions of primary votes, but with no possible issue other than personal, would be highly detrimental to the country's progress. If the governor were to be elected by direct vote, then he might consider himself to be the superior to the chief minister, who was merely returned from a single constituency, and this might lead to frequent friction between the governor and the chief minister. But under the parliamentary system of government prescribed by the constitution, the governor was to be constitutional head of the state, the real executive power being vested in the ministry responsible to the legislature. When the whole of the executive power is vested in the council of ministers, if there is another person person who believes that he has got the backing of the province behind him, and therefore at his direction he can come forward and intervene in the governance of the province. It would really amount to a surrender of democracy. The expenses involved and the elaborate machinery of elections would be out to proportion to the powers vested in this governor, who was to act as a mere constitutional head. A governor elected by adult franchise to be at the top of the political life in the state would soon prefer to be the chief minister or a minister with effective powers. The party in power during the election would naturally put up for governorship a person who has not as outstanding as the future chief minister, with the result that the state would not be able to get the best man of the party. All the process of election would have to be gone through only to get a second-rate man of the party would have to be gone through only to get a second-rate man of the party elected as governor. Being subsidiary in importance to the chief minister, he would be the nominee of the chief minister of the state, which was not a desirable thing. Through the procedure of appointment by the president, the union government would be able to maintain intact its control over the states. The method of election would encourage separatist tendencies. The governor would then be the nominee of the government of the particular province to stand for the governorship. The stability and unity of the governmental machinery of the country as a whole could be achieved only by adopting the system of nomination. He would be more detached figure acceptable to the province. Other he could not function, and yet he may not be part of the party machine of the province. On the whole, it would be probably be desirable to have people from outside eminent in something, education or other fields of life, who would naturally cooperate fully with the government in carrying out the policy of the government and yet represent before the public something above politics. The arguments which were advanced in the Constituent Assembly against nomination are also worthy in consideration. A nominated governor would not be able to work for the welfare of the state because he would be a foreigner to that state and would not be able to understand its special needs. There was a chance of friction between the governor and the chief minister of the state, no less under the system of nomination, if the premier of the state did not belong to the same party as the nominated governor. The argument that the system of election would not be compatible with the parliamentary or cabinet system of government is not strong enough in view of the fact that even at the center there is an elected president to be advised by the council of ministers. Of course, the election of the president is not direct but indirect. An appointed governor under the instruction of the center might like to run the administration in a certain way contrary to the wishes of the cabinet. In this tussle, the cabinet would prevail and the president appointed governor would have to be recalled. The system of election, therefore, was far more compatible with good, better and efficient government plus the right of self-government. The method of appointment of the head of the state executive by the federal executive is repugnant to the strict federal system as it obtains in the USA and Australia. In actual working, it might be said that in states where one party has a clear majority, the part played by the governor has been that of a constitutional and impartial head. But In those states where there are multiple parties with an uncertain command over the command over the legislature, the governor has acted as a mere agent of the center in various matters, such as inviting a person to form a ministry because he belonged to the ruling party at the center, even though he had no clear following, as in the case of Sri Rajgopalachari in Madras after the general election in 1952, or bringing about the removal of a ministry having the confidence of the legislature by means of a report under Article 356, as happened in Kerala in 1959 in the case of communist ministry headed by Sri Nambudiri Pad. Nevertheless, there is one aspect in which the system of appointing an outsider by the center has proved to be beneficial, and that it is in the prevention of disruptive and separatist forces from impairing the national unity and strength as might otherwise have been possible without the knowledge of the center. Under a locally elected governor, it is from this standpoint alone that one can tolerate the patently undemocratic instances of adopting a retiring or a retired member of the Indian civil service or the Indian administrative service who is obviously a veteran bureaucrat of the armed forces or of the armed forces as a governor. A governor gets a monthly emoluments of rupees 36,000 together with the use of an official residence free of rent, and also such allowances and privileges are specified in the governor's emoluments, allowances and privileges Act 1982 as amended in 1998 with effect from 1/1/1996. The emolument and allowances of a governor shall not be diminished during his term of office. Article 153, Clause 3 to 4. The governor has no diplomatic or military powers like the president, but he possesses executive, legislative, and judicial powers analogous to those of the president. Executive, apart from the power to appoint his council of ministers, the governor has the power to appoint the advocate general and the member of the state public service commission. The ministers as well as advocate general hold office during the pleasure of the governor, but the members of the state public service commission cannot be removed by him. They can be removed only by the president on the report of the Supreme Court on reference made by the president, and in some cases on the happening of certain disqualifications. Article 370. The governor has no power to appoint judges of the state high court, but he is entitled to be consulted by the president in the matter. Article 217(1). Like the president, the governor has the power to nominate members of the Anglo-Indian community to the legislative assembly of his state if he is satisfied that they are not adequately represented in the assembly. But while the president's corresponding power with regard to the House of the People is limited to a maximum of 2 members, in the cases of the governor, the limit is 1 member only. Since the Constitution 23rd Amendment Act 1969, Article 333, as regards to the upper chamber of the state legislature, the states where the legislature is bicameral, namely the Legislative Council, the governor has a power of nomination of members corresponding to the power of the president in relation to the Council of States, and the power is similarly exercisable in respect of persons having special knowledge or practical experience in respect of matters such as literature, science, art, cooperative movement, and social service. Article 171(5). It is to be noted that the cooperative movement is not included in the corresponding list relating to the Council of States. The governor can so nominated 1/6 part of the total members of the Legislative Council. Legislative, as regards regards legislative powers, the governor is a part of the state legislature, Article 164. Just as the president is a part of parliament, again, he has a right of addressing and sending messages and summoning, proroguing, and dissolving in relation to the state legislature, just as the president has in relation to parliament. He also possesses a similar power of causing to be laid before the state legislature the annual financial statement, Article 202, and of making demands for grants and recommending money bill, Article 207. His powers of veto over state legislation and making ordinances are dealt with separately. Chapter 14, Governor's power of veto and ordinance making power of governor. Judicial. The governor has the power to grant pardons, reprieves, respites, or remission of punishments, or to suspend, remit, or commute the sentence of any person convicted of any offense against any law relating to a matter to which executive power of the state extends, Article 161. He is also consulted by the President in the appointment of the Chief Justice and the judges of the High Court of the states. Emergency power. The governor has no emergency powers to meet the situation arising from external aggression or armed rebellion, as the President has Article 352 subclause 2, but he has the power to make a report to the President whenever he is satisfied that a situation has arisen in which government of the state cannot be carried on in accordance with the provisions of the Constitution. Article 356, thereby inviting the President to assume to himself the functions to the government of the state or any of them. This is popularly known as the President's rule. The Council of Ministers, as has already been stated, the governor is a constitutional head of the state executive and has therefore subject to his discretionary functions not below to act on the advice of Council of Ministers, Article 163. The provision relating to the Council of Ministers of the governor are therefore subject to exceptions to be stated presently, similar to those relating to the Council of Ministers of the President. At the head of the State Council of Ministers is the Chief Minister, corresponding to the Prime Minister of the Union. The Chief Minister is appointed by the Governor, while the other ministers are appointed by the Governor on the advice of the Chief Minister. The Council of Ministers shall be collectively responsible to the Legislative Assembly of the state and individually responsible to the Governor. The ministers are jointly and severally responsible to the legislature. They are publicly accountable for the acts or conducts in the performance of duties. Any person may be appointed as minister provided he has the confidence of the Legislative Assembly, but he ceases to be a minister if he is not or does not remain for a period of 6 consecutive months a member of the state legislature. The salaries and allowances of ministers are governed by the laws made by the state legislature, Article 164. It may be said that in general the relation between the governor and his ministers is similar to that between the President and his ministers, with this important difference that while the Constitution does not empower the President to exercise any function in his discretion, it authorizes the governor to exercise some functions on his discretion. In this respect, the principle of cabinet responsibility in the states differs from that in the Union. Article 161(3)(1) says, there shall be a council of ministers to aid and advise the governor in the exercise of his functions, except in so far as he is by or under this Constitution required to exercise his function or any of them in his discretion. It is because of this discretionary jurisdiction of the governor that no amendment was made by the the 42nd Amendment Act in Article 163(1) as in Article 74(1), which we have noticed in Chapter 11. In the exercise of the functions which the governor is empowered to exercise in his discretion, he will not be required to act according to the advice of his ministers or even to seek such advice. Again, if question arises whether any matter is or is not a matter as regards which the governor is required by the Constitution, and is validity of anything done by the governor shall not be called into question on the ground that he ought or ought not to have acted in his discretion. Article 163(2). The functions which are especially required by the Constitution to be exercised by the governor in his discretion are Para 9(2) of the 6th schedule, which provides that the governor of Assam shall in his discretion determine the amount payable by the state of Assam to the direct council as royalty occurring from licenses for minerals. Article 239(2), added by the Constitution 7th Amendment Act 1956, which authorizes the President to appoint the governor of a state as the administrator of an adjoining union territory, and provides that where a governor is so appointed, he shall exercise his functions as such administrator independently of his council of ministers. Besides the above functions to be exercised by the governor in his discretion, there are certain functions under the amended Constitution which are to be exercised by the governor on his special responsibility, which particularly means the same thing as in his discretion, because though in cases of special responsibility he is to consult his council of ministers, the final decision shall be in his individual judgment, which no court can question. Such functions are under Article 371(2) as amended. The President may direct that the governor of Maharashtra or Gujarat shall have a special responsibility for taking steps for the development of certain areas in the states, such as Vidarbha, Saurashtra. The governor of Nagaland shall, under Article 371(a)(1)(b), introduced in 1962, have similar responsibility with respect to law and order in that state, so long as internal disturbances caused by the hostile Nagas in that state continue. Similarly, Article 371(c)(1), as inserted in 1971, empowers the President to direct that the governor of Manipur shall have special responsibility to secure the proper functioning of the committee of the Legislative Assembly of the state, consisting of the members elected from the hill areas of the states. Article 371(f)(g), inserted by the Constitution 36th Amendment Act 1975, similarly imposes a special responsibility upon the governor of Sikkim for peace and for equitable arrangement for ensuring the social and economic advancement of different sections of the population of Sikkim. In discharge of such special responsibility, the governor has to act according to the discretion issued by the President from time to time, and subject thereto, he is to act in his discretion. In view of the responsibility of the governor to the President and the fact that the governor decision as to whether he should act in his discretion in any particular matter is final, Article 163 clause 2, it would be possible for a governor to act without ministerial advice in certain other matters according to the circumstances, even though they are not specifically mentioned in the Constitution as discretionary functions. As an instance to the point may be mentioned in making of a report to the President under Article 356 that a situation has arisen in in which the government of the state cannot be carried on in accordance with the provisions of the Constitution, such a report may possibly be made against a ministry in power. For instance, if it attempts to misuse its power to subvert the Constitution, it is obvious that in such a case the report cannot be made according to the ministerial advice. No such advice again will be available where the ministry has resigned and another alternative ministry can be formed. The making of report under Article 356 thus must be regarded as a function to be exercised by governor in the exercise of his discretion. Obviously, the governor is also the medium through whom the union keeps itself informed as to whether the state is complying with the directives issued by the union from time to time. Further, after such a proclamation as to failure of the Constitution, machinery in the state is made by the President. The governor acts as the agent of the President as regards those functions of the state government which have been assumed by the President under the proclamation Article 356 subclause 1A. In some other matters, such as reservation of a bill for consideration of the President, Article 200, the governor may not always be in agreement with the Council of Ministers, particularly when the governor happens to belong to a party other than that of the ministry. In such cases, the governor may, in particular function, be justified in acting without ministerial advice if he considers that a bill in question would affect the powers of the union or contravene any of the provisions of the Constitution, even though his ministry may be of the different opinion. It is obvious that as regards matter on which the governor is empowered to act in his discretion or his special responsibility, the governor will be under the complete control of the President. As regards other matters, however, though the President will have a personal control over the governor, though his power of appointment and removal, it does not seem that the President will be entitled to exercise any effective control over the state government against the wishes of the Chief Minister, which enjoys the confidence of the state legislature. Though, of course, the President may keep himself informed of the affairs in the state through the reports of the governor, which may even lead to the removal of the ministry under Article 356 as stated above. A sharp controversy has of late arisen upon the question whether a governor has the power to dismiss a council of ministers headed by Chief Minister on the assumption that the Chief Minister and his cabinet have lost their majority in the popular house of the legislature. The controversy has been particularly intriguing inasmuch as two governors acted in contrary directions under similar circumstances. In West Bengal in 1967, Governor Dharm Veera, being of the view that the Union Front Ministry led by Ajay Mukherjee has lost majority in the Legislative Assembly owing to defections from the party, asked the Chief Minister to call a meeting of Assembly at the short notice, and on the latter refusal to do so dismissed the Chief Minister with his ministry. On the other hand, in Uttar Pradesh in 1970, Governor Gopal Reddy dismissed Chief Minister Charan Singh on a similar assumption without even waiting for the verdict. Charan Singh on a similar assumption without even waiting for a verdict of the assembly, which was scheduled to meet only a few days later. Quite a novel thing happened in Uttar Pradesh in 1908 when the governor Romesh Bhandari, being of the view that the Chief Minister Kalyan Singh ministry has lost majority in the assembly, dismissed him without affording him opportunity to prove his majority on the floor of the House, and appointed Sri Jagdambika Pal as the Chief Minister, which was challenged by Sri Kalyan Singh before the High Court, which by an interim order put Sri Kalyan Singh again in position as the Chief Minister. This order was challenged by Sri Jagdambika Pal before the Supreme Court, which directed a composite floor test to be held between the contending parties, which resulted in Sri Kalyan Singh securing majority. Accordingly, the impugned interim order of High Court was made absolute. Before answering the question with reference to the preceding instances, it should be noted that the cabinet system of government has been adopted in our constitution from the United Kingdom, and some of the salient conventions underlying the British system have been codified in our constitution in the absence of anything or to the contrary in the context. Therefore, it must be concluded that the position under the Constitution is the same as in the United Kingdom. In England, the ministers, being legally the servants of the Crown, at law of the Crown, has the power to dismiss each minister individually or collectively, but upon the growth of the parliamentary system, it has been established that the ministers collectively hold their office so long as they command a majority in the House of Commons. This is common as the collective responsibility of ministers. The legal responsibility of the ministers as a collective body to the Crown has thus been replaced by the political responsibility of the ministry or parliament, and the Crown's power to dismiss a prime minister of his cabinet has become obsolete. The last instance being 1783, the Crown retains, however, his power to dismiss a minister individually, and in practice this power is exercised by the Crown on the advice of the Prime Minister himself when he seeks to weed out an undesirable colleague. Be that as it may, the above two propositions as they exist today in England have been codified in clause 1 and 2 of Article 164 of our Constitution as follows: and the ministers shall hold office at the pleasure of the governor. The Council of Ministers shall be collectively responsible to the stately assembly of the state. In the above context, the legitimate conclusion that can be drawn is that the governor has the power to dismiss an individual minister at any time. He can dismiss a council of ministers or the chief minister, whose dismissal means a fall of the council of ministers only when the legislative assembly has expressed its want of confidence in the council of ministers, either by direct vote of no confidence or in censure, or by defeating an important measure or the like, and the governor does not think fit to dissolve the assembly. The governor cannot do so at his pleasure on his subjective estimate of the strength of the chief minister in the assembly at any point of time, because it is for the legislative assembly to enforce the collective responsibility of the council of ministers to itself under Article 164(2). The above view of the author has been upheld by the Supreme Court in S.R. Bommai versus Union of India in 9 judgments by observing that wherever a doubt arises whether a ministry has lost the confidence of the House, the only way of testing is on the floor of the House. The assessment of the strength of the ministry is not a matter of private opinion of any individual, be he the governor or the president. The Advocate General. Each state shall have an Advocate General for the state, an official corresponding to the Attorney General of India and appointed by the governor of the state shall hold office during the pleasure of the governor. Only a person who is qualified to be the judge of a high court can be appointed Governor General. He receives such remunerations as the governor may determine. He shall have the right to speak and to take part in the proceedings of but no right to vote in the houses of the legislature of the state, Article 177. This is all about today's state executive in the series of our constitution. Thanks, regards.